Welcome, everyone, to the Oxford, Virginia Legal Dialogues. I'm Ruth Mason. I'm the Edwin S. Cohen Distinguished Professor of Law and Taxation at the University of Virginia. I'm Director of the Virginia Center for Tax Law and a Max Planck Law Fellow. My co-convener for this series is Tsilly Dagan, who's a professor of taxation law at Oxford University and one of the directors of the MSc in taxation at Oxford University Faculty of Law. The goal of this workshop is to build bridges across academic disciplines by bringing academics together with tax academics together with non-tax academics. Concept is simple. Tsilly and I invite academics that we admire and discuss their work here on Zoom. And today we have historian Ron Harris to talk about his forthcoming book entitled Empire Limited: Law and the Rise of Multinational Companies in the First Era of Globalization. I know that everyone is excited to have Ron here today. And Ron, you actually broke the internet. We have more people register than we could accommodate. So I do need to mention a couple of items of housekeeping. First, Ron will present his chapter. The chapter that we're looking at today is Beyond Borders, Private International Company Law's Formative Era. And then Tsilly and I will make some comments and Ron will respond, and then we'll have a Q&A. So Tsilly's going to keep the queue today. If you would like to be in the queue, just use the raise hand function. Click participants and then raise hand. Also, please let us know your name and institutional affiliation in the chat so we know who you are. And with that, let me introduce Ron Harris. Ron is the Kalman Lubowsky Professor of Tax Law and History and former Dean at the Faculty of Law in Tel-Aviv University. His main research field is the history of the business corporation. He studies the business corporation in Britain and comparatively, and in the wider context of legal and economic history, the history of industrialization, capitalism, colonialism, and globalization. He also works on the history of other forms of business organization and other legal economic institutions, including contracts and property rights. His additional research interests include the methodology of legal economic history, the history and policy of bankruptcy and consumer credit, and Israeli legal history. In the United States, Ron has been a visiting professor at UC Berkeley, USC, Cornell, and in the UK at the London School of Economics, and he's also been a visiting fellow in Oxford. Among other publications, many other publications, Ron is the author of 3 books: Going the Distance, Eurasian Trade and the Rise of the Business Corporation 1400 to 1700, Industrializing English Law, Entrepreneurship and Business Organization 1720 to 1844, and Israeli Law, The Formative Years, 1948 to 1977. So with that introduction, I'll hand it over to Ron to get us started.
Thanks very much, Ruth. I'll just share my slides. You can see them now in presentation mode, I guess. And so I would like, first of all, to thank Ruth and Tsilly and the colloquium for inviting me. I'm not a tax person, as you know. That's, as I understand, the purpose of the colloquium is to be a meeting place for tax scholars with other scholars. And I'm, as Ruth generously presented me, primarily a legal historian, economic historian, to some extent business historian. My book project as a whole doesn't touch upon taxation. That's the tentative table of content. It's probably not the final one. I'll be shifting around some of the chapters, maybe merge some chapters. So the book as a whole doesn't deal directly with taxation. The present chapter, Beyond Borders, which is currently chapter 4, has a section on taxation. And in today's presentation, in order to make the meeting more effective, I'll be driving through the chapter and focus on that section on taxation. And I believe that here I can benefit a lot from your comments and from your questions in order to further work on that taxation project. So for those in this form, I think that the first couple of slides are unnecessary. So you all understand how important are offshore tax havens, how important is the incorporation of business corporations in a variety of jurisdictions for various purposes. Taxation, reducing or avoiding taxation is only one of them. These slides are high. I mean, I'm sure that you all know how important it is these days for business corporation, business corporate groups to choose where to incorporate for a variety of purposes. That's, for example, a slide on how Lehman Brothers subsidiaries looked like just before it collapsed, incorporated all over the globe in a variety of jurisdictions for a variety of purposes. Taxation is just one of them. There are other purposes for choosing where to incorporate, including asset protection from bankruptcy, privacy, kind of concealing of information or increased privacy, and additional estate planning and things like this. So that's kind of how my current chapter connects to what you might be having interest in this colloquium. So now a bit about the general scope of my scholarship and the book and then the chapter. As mentioned by Ruth, I was working so far. I'm primarily working on the history of the business corporation. My first book was on business corporations during the British Industrial Revolution. My second book was on the very early business corporations, the East India companies, the British and Dutch East India companies in the early 1600s. And I then worked on later period over the years, mostly in separate articles dealing with a variety of aspects of the period 1844, in which general incorporation was introduced in Britain, up until World War I, and sometimes beyond World War I. So much of the literature in the period is interested in how corporations are being owned, whether they are widely held or by controllers. The literature is interested in the rise of the business corporation. I was interested, and jointly with others, including Naomi Lamoureux, Jean-Laurent Rosenthal, and Tim Genan, in the contractual freedom in the period, in limited liability in the period, in the emergence of private companies, in theories of legal personality. And now I've reached a stage in which I started showing more interest in the globalization of company law. So after working on other aspects, I've reached this aspect of globalization. I focused on it and decided to devote a full book, which I'm working on for the last few years, maybe 5 years, on the globalization of company law and the business corporation from Britain to the empire and beyond the empire. And the context in which this globalization takes place is composed of two main paradigm shifts. One of them is from what is called the chartering era in incorporation of business corporations to the general incorporation era. That is, from a stage in which one could form corporations only by resorting to the state, asking for the state's permission, and getting a charter, specific charter for specific corporation from the state, usually after showing some public benefit or some benefit to the government or to the rulers from incorporating a corporation. So this was how corporations were incorporated from Britain, let's say from 1550 or so, if not before, up until 1844. And then in 1844, you have this paradigm shift into general statutes that allow free incorporation, free access to the joint stock business corporate form, and contractual freedom in designing the companies, and a shift from public purpose to private purpose of corporations. And in fact, a shift of company law, gradual shift of company law from being part of public law to being part of private law. So that's one paradigm shift. And this paradigm shift was accompanied by reconceptualization of what corporate entities, corporate personalities are about. from what could be called as the concession theory or grant theory. A corporation is created by the state, by the crown, by the governor, by parliament, to a different conceptualization, which is either, and then in the second half of the 19th century, two competing theories have emerged to replace the previous one. One of them is termed contractual or aggregate theory. Some would term it partnership theory, that is an aggregation of individuals association of individuals create a business corporation. The other is that the corporation is indeed, in fact, a natural person, a real person. This is a phenomenon that the law did not create, but only recognizes because it is there. So this is one stage, one paradigm shift. The other is connected to the expansion of the British Empire. The British Empire has expanded dramatically from the end of the Napoleonic Wars until World War I. You can see it on the map. The expansion, at the end of this period of expansion, the British Empire controlled about a quarter of the world population and about a quarter of Earth land area, an expansion of British political control, sovereign control. Together with it, there was another aspect, which is part of the first era of globalization, an outflow of capital from Britain to the rest of the globe. The capital that accumulated during the first industrial revolution flew out of Britain to North America, South America, Australia, Africa, as you can see here, and parts of Asia. The first era of globalization also involved, in addition to expansion of empire and capital flows, also increase of international trade, usually under free trade regimes, and also, and this is the peak of the first era of globalization that ended more or less with the outbreak of World War I. Together with this, there was also a significant migration out of Britain to the settler colonies of Britain overseas. Now, with the expansion of the empire, one could also see expansion of company law from Britain to the rest of the empire. You can see now kind of animation that shows the expansion in the next half a minute or so. The blue pins are within the empire. The green pins are new company laws outside of the British Empire. You can see that the globe is being covered by company laws. This expansion of company laws, let's move on. Sorry. So with this expansion of company law, now incorporators, entrepreneurs, investors had a choice where to incorporate. If before this paradigm shift, which was connected to globalization and imperialism, one had to incorporate only in Britain. British could only incorporate in Britain through parliament or through the crown. Now they could choose where to incorporate. They could incorporate anywhere in the empire, in a Canadian province, in an Australian province, in India, or in Hong Kong for that matter, or they could decide to incorporate outside of the empire, let's say in Argentina, as they did, or in China, if they wanted, things like this. So, we have this expansion of company law. We have the outflow of capital. The capital that flew out of Britain was invested partly in government bonds, that is in public finance, and mostly, and as time passed, more and more in private finance, and primarily in corporations. You can see railway bonds were attracting some investment, railway shares attracted investments, and shares in other equity investment in other sectors have also expanded dramatically as time passed. And I've investigated as part of the book project many joint stock business corporations that operated outside of Britain. Many of them were incorporated in Britain, some of them were incorporated elsewhere. And I was trying to figure out how did they decide where to incorporate, how to incorporate, where to list themselves in stock exchanges, and later on what to do in terms of taxation. So I've covered more than 60 companies so far in terms of case studies from which I gain insights for my purposes. Now, with these things happening, the field of private international law has expanded with globalization primarily. You can see here, I'm just briefly going through the introduction, the first part of the chapter. So you can see the growing use of the term private international law, as can be seen in red here, and the growing use of the term conflict of laws, which is seen here in blue, and it expands with globalization. And with it, expanded the entire field of conflict of laws. That is, once you have people in a variety of places, you have trade around the globe, conflict of law became an issue, private international law became an issue, and over time, one specific field of private international law, that is private international company law, also became something the jurists had to deal with. And that's what this aspect of the expansion of private international law is the aspect that the current chapter is focusing on. You can see that it was approached both by jurists in private international law and jurists in company law. I think that overall jurists in company law led the way. They were more intimately connected to the field, better understood the field, its problems, the fact that you have more and more companies from the list that I've shown before that operated in more than one place and often more than two places. They had shareholders in a variety of places, directors in a variety of places, business in a variety of places. They were listed in stock exchanges, often in more than one place, not very often, but in some of the companies, there was a dual listing, as it is called, of shares in more than one stock exchange, sometimes in London and Bombay, sometimes in London and Hong Kong, etc. And the expansion of the field of private international company law followed the expansion, as I said, of the companies themselves. Once you have companies, you have legal disputes, you have to deal with these legal disputes. The first ones to deal with the disputes were judges. So much of the law in the field is case law. And then you have jurists, sometimes academic jurists, sometimes more practically oriented jurists that started organizing the field, some of them coming from private international law, some of them coming from company law. The chapter deals with them. I won't get into the details here. And over time, as we approach World War I, the sets of issues are becoming clearer and clearer. And here is a list of the main sets of issues that were dealt in by courts and conceptualized by jurists. The first of them is whether a company from another jurisdiction will be recognized as a company in our jurisdiction. That is the status of foreign corporations. Will they be viewed as valid corporations? Will they be treated as corporate entities, or will the corporate entities be ignored because they were not recognized by the domestic legal system? A second theme that grew in importance is internal affairs. How do we decide which law would apply to the internal conflicts of the corporation? Which form would apply to these internal conflicts? For example, conflicts between minority and majority shareholders, between shareholders and directors, conflicts about the nature of the voting rights of shareholders, about the distribution of dividends, about the breach of fiduciary duties. So internal affairs were a second theme that had to be sorted out. A third theme was what to do in the winding up when a corporation is insolvent, has to be dissolved, is in the process of being winded up or going through bankruptcy. Which law would control it? The law of the place of incorporation, the law of the location of the creditors, the law of the contracts which created the credit or the liabilities, a full set around this. And then there were a few non-corporate issues that also had to be sorted out and figure out which law would apply to each of these. which doctrines, which forms, antitrust, I won't mention them here unless I'll be asked about them, trading with the enemy, that is during wartime, trading with German companies or German counterparties, and then taxation, which is, I guess, what's of most importance to you, and I try to get to taxation as fast as I can. So as for the question whether foreign corporations will be recognized, I think that I'll show only one slide today. So there was some common law rulings about this. There was a notion of universal principles, as much as there was a debate as to whether private international law is part of international law or part of domestic or municipal law. There were some universal principles of committee, for example, that governed the question of whether a foreign company should be recognized or not. There were some bilateral treaties, and there were some model laws that were recommended by international associations and sometimes adopted by some of the jurisdictions. Britain was one of those that had to consider these model laws. And then there was some specific domestic British legislation passed by the British Parliament as the Companies Act of 1907, which was the first Companies Act to deal with foreign corporations. And then there was the question of choice of law. The second theme is choice of law in internal affairs, shareholders, directors, etc. And the common wisdom is that common law states prefer place of incorporation, place of registration, as the doctrine that governs the choice of law, whereas continental law, continental tradition follows the real seat or domicile doctrine. I think that this common wisdom is really not accurate. Apparently, it took Britain quite a while to converge into recognizing the place of incorporation as the dominant way of choosing law. The US is a different story. For sake of time, I won't get to the US unless I'll be asked for. And in continental Europe, not all jurisdictions follow the real seat doctrine. Some follow the place of incorporation doctrine. Just to make it clear, if it's not intuitive, place of incorporation means that wherever you incorporate, the law of the place in which you were born, the corporation was born, was incorporated, was registered, would dominate all litigation on internal affairs. Real seat looks at the center of gravity of the corporation, not where it was born, but rather where it is being controlled from, managed from, or things like this. So these were the two approaches that have developed during my period, so to speak, between roughly 1844 and 1914. And I won't get into this in detail today. There are some more specifications in the chapter. And then there is the question of the intersection between those questions of choice of law and the question of how do we conceptualize the juristic personality. If you view it as subjected to the grant theory, it's hard to imagine how you'll not apply the place of incorporation on it. If you view it as something like a partnership, you might just want to look through the corporate entity into the shareholders, see what their domicile is, and base the law of their domicile over internal affairs. If you have some sort of a real or natural person theory as your leading theory for corporate personality, then you might think of corporations like human beings as ones that can be born in one place and move to other places. I'll get to this when I'll get to taxation soon. Cross-border insolvency is the most complicated of all the four themes that I've mentioned today. Again, I won't get into the details, but the problems with applying private international law, applying law based on private international law principles to insolvency was not solved up until today. There is today still a prevalent universal approach. There is today a territorial approach. A universal approach says that one jurisdiction would govern the entire insolvency procedures. Territorial would separate to different territories based on creditors' domicile or the place of the assets. And there are attempts to combine the two, like modified universalism or cooperative territorialism. Those of you who are familiar with the field will know what I'm talking about. But issues were first dealt in my period. They were sorted out in a variety of ways. I'm not sure that they were always sorted out in the British Empire in a manner that served the British government or British creditors or British entrepreneurs. That's something I'm trying to figure out in the chapter. I'm still working on the topic. And now I'm turning to the field that is really your field, so to speak, multinational corporations, and I'll be rushing through it for the sake of time. So I covered a few cases. One set of cases involves two corporations. Both of them were incorporated in Britain, the Calcutta Yacht Mill Company and the Cesena Sulfur Company. They were both incorporated in Britain. They operated outside of Britain, one of them in India, the other in Italy. One of them had mills for processing yacht, had many of the shareholders in India, but most of the directors in Britain. The company's account books and things like this were kept in India, but the meetings of the board of directors and the general shareholders meeting were held in India. Somewhat similarly, in the Italian case, there was some aspects in Italy, some aspects in Britain. And the question then was whether the two companies will be subjected to income tax in Britain. The two cases were decided together by the Exchequer Division in 1876. And the Inland Revenue Act says that income tax, persons residing in the United Kingdom will be subjected to British taxation of all their practically all of their universal income. And the question then was whether these two companies are persons residing within the United Kingdom. And so it was taken for granted that one has to decide about the place of residence of the companies rather than the individual shareholders. But the question was, where do they reside? And I won't get into the full details of the case. What I will be trying to summarize, you can have a look at the slide here. It seems as though the barons were confused. They in fact applied simultaneously the place of incorporation and the real seat doctrine to both companies. They did not separate clearly between the two. They blended the two in their own thinking, both Huddleston and Kelly. And they say that place of incorporation is important, but just as individuals can migrate, so the corporations can migrate. But in fact, these two corporations did not migrate to Italy or to India. They are still residing in Britain, given the fact that much of their management and control are taking place in Britain. They focused on it rather than the business activities. And the bottom line was that both companies were subjected to British taxation, but the ruling did not provide clear guideline for how to do tax planning for the future, because it provided too many factors, did not clearly say which way did the court attribute to each of these factors, each of these considerations. It was clear that you cannot easily avoid British taxation. Another case in the line is the De Beers Mining Company. The Beers Mining Company was a consolidation of many mining companies operating in South Africa into a single company incorporated in the Cape Colony in South Africa, not in Britain. Unlike the previous case here, the place of incorporation is in the Cape Colony. The controllers of the company included Cecil Rhodes, Nathan Rothschild, and some similar famous characters of the age of high imperialism and high finance. The company's operation was all done, the mining operation was all done in South Africa, but much of the management, as you can see here, was done in Britain. Like the company had office in London, the company held a sort of board meetings in London. Many of the directors were in London. There was a sort of a board in Kimberley in South Africa, but the London board called the shots. More of the directors were in London. And so the question was whether this company that was incorporated outside of Britain was subjected to British taxation. And the bottom line here was that the Beers mining company was subjected to British taxation. And they kind of dismissed the argument that the company that was incorporated outside of Britain had no existence in Britain. They rejected the American principle, which relied only on place of incorporation. And they decided that the effective control, in a way, they preferred the real seat test over the place of incorporation test for tax purposes in this pivotal holding by the House of Lords. Some very nice statements. Just as an individual may have a foreign nationality and yet reside in the United Kingdom, so may a company. It can reside in the United Kingdom for tax purposes and be subjected to the UK taxation because of this. So now, after the Beers decision, it was made clear that real entity test seems to be the leading test for deciding the place of residence of the company, not place of incorporation, but real seat. So in order to avoid British taxation, you cannot just incorporate it outside of Britain. You have to make sure that the company will not be controlled, effectively controlled from Britain. And I'll rush again through some of these slides and just want to mention one more case, which is the Egyptian Delta Textile Company, a case beyond our period, 1928. In that case, this determined that if a company that was registered in Britain, in effect was controlled outside of Britain, this case from Alexandria, it will not be subjected to British taxation. What I take from all of these cases is that over time, certainty has increased. One could expect how courts would rule issues. One could plan taxation, and shrewd and smart and skillful lawyers and accountants could do exactly what was done by the Vesti group or corporate group. This group made sure that it will avoid, I don't know whether James Hollis from Oxford is among those who participate today, but he has a brilliant article, a brilliant case study that shows how the Vesti group made a tax plan in order to minimize its tax payment in Britain by having many of its companies registered outside of Britain, in Latin America, often in Argentina, in the United States, often in New York, and by using various tools of transfer prices, for example, in order to reduce payment of tax in Britain, by making sure that income generated outside of Britain will not be transferred into British companies, and because taxation in Britain at the time, because anyway was higher than anywhere else in those jurisdictions, and particularly after the outbreak of World War I, the shrewd tax planning allowed the Vesti group to pay very little, almost no tax at all in Britain, after the outbreak of the war, in fact, the controllers, the two Vastey brothers, migrated temporarily to Buenos Aires in order to even further reduce their tax payment. By migrating to Argentina, to Buenos Aires, they created a situation in which the partnership at the top of the pyramid, at the top of the corporate group, was considered to be a non-British partnership because the partners were non-residents of Britain, but rather residents of Argentina. So this is an excellent example for how beyond the screen, under the surface, under the radar, tax planning first emerged around before and during World War I, thanks to the certainty provided by the rulings of the courts. The certainty doesn't necessarily mean that the courts always ruled in a manner that allowed people to easily avoid taxation, but it allowed them to know what the bright line rules are and how to use those bright line rules and be on the right side, that is on the low tax payment or the non-tax payment side, once they planned their corporate group structures. Very last issue. So in taxation, the government could not really control tax planning and tax avoidance. In one other aspect that I would like to mention, more or less around the same time, trading with the enemy, that is trading in this case with the German enemy during World War I, the courts, the House of Lords, in a very famous case, the Daimler case, the court ruled that it would totally ignore the corporate entity and look behind it into the shareholders. And if the shareholders are Germans, then the company is an enemy company and one could not trade with it. And if one owed money to that company, one does not have to pay money to that company because it's an enemy company and one is not allowed to pay money to an enemy company to kind of pay the debts, pay for supplies received from enemy companies. And in case of enemy legislation, the courts totally ignored the corporate entity. In taxation, the courts did not do it. They looked at the corporation, they looked at its residency, they looked at foreign corporations, they applied very strict rules for the issues, but those strict rules allowed for tax planning, which drives me to the very last slide, which in a way summarizes my argument in this part of the chapter, in the chapter as a whole. The fact that one could decide where to incorporate, and one had many choices for selecting jurisdiction to incorporate it, one opened up the floor for a tax planning and offshore tax havens. One could form corporate groups and locate different subsidiaries in different jurisdictions, put the controlling corporation or the controlling partnership in a jurisdiction of their choice. They had sufficient predictability of the choice of law rules in taxation. They had sufficiently well-trained, highly experienced lawyers and accountants in the City of London that allowed them to create tax planning as the Vastey Group did. And in a way, the bottom line of my chapter for kind of scholars in your field is that if the common wisdom in the past was that tax planning and tax havens began only in the 1970s or in the 1950s or in the interwar period, I'm trying to show that it all started before 1914, and it was not inevitable. One could get different private international law rules. One could get different rules in terms of choice of law for taxation. One could get different legislation. One could get legislation which is somewhat analogous to the legislation with respect to enemy companies in order to minimize or prohibit altogether the ability to use offshores. And I think that that's a good point for me to stop. Thanks very much.
Thank you very much, Ron. So for those of you who've logged in late, we've interrupted Ron's start with some technical issues. And so his talk expanded a little over our usual time, but we will expand the rest of the session to allow for comments. So thank you very much, Ron. As is often the case with Ron's work, the chapter and the entire book, in fact, are, for me, an exercise in humbleness. Not just due to his meticulous work on providing an impressively rich and deep and wide outlining of the legal landscape of the late 1800s and early 1900s regarding M&Es, but also for the by now cliche saying that there is nothing new under the sun. In fact, the chapter, and as I said, the book more generally, demonstrates that the landscape of the international tax regime that we are seeing today, which we might have thought is a result of the current age of globalization, and particularly a result of the technological revolution of the past few decades, has its roots in the very early stages of globalization in the late 19th century and early 20th century. So the historical tactics employed by multinational enterprises back then to navigate and exploit legal frameworks for their benefit continue to resonate in contemporary business practices, particularly in the tax avoidance and regulatory arbitrage areas. And states that initially created the opportunities for M&Es to navigate the system bear the costs of their own legal creations. So what Ron calls the mumble jumble of legal frameworks, a wide variety of legal regimes across national borders, is for tax planners their playing field, where they can and do use the basic building blocks of the system to shift profit and tax liability to low or no jurisdictions. Importantly, as Ron notes, the phenomenon is not limited to tax rules and liabilities. This mumble jumble of legal frameworks allows M&Es to mix and match legal rules and regulations in various jurisdictions to negotiate and enjoy public goods and benefits in multiple jurisdictions simultaneously. So Ron's work allows, indeed requires us to take a step back and watch the process as it emerges, to think about the reasons that brought us to where we are, and perhaps even to draw a lesson from history going forward. So let me start with from the end, from where we are today. As Ron mentions in his introduction, and I quote, "In the last few decades of the 19th century, business corporations escaped the control of states." I think we're seeing the results of this grand escape in tax today. So tax, of course, is linked at its core to the coercive power of the state. And the ability of M&Es to escape this power increasingly turns tax from a compulsory obligation into what has become, at the beginning of the 21st century, almost elective. And there are two elements to this transformation, and Ron's work demonstrates them both, and both their roots. One is the strategies that multinational enterprises employ, and the other is states' reaction. As I will explain, there are inherent asymmetries between these two types of actors, multinationals on the one hand and states on the other, and thus establishing the rules of the game, which Ron describes, matters. It matters a lot. So starting with multinational enterprises strategy, a key factor in M&E strategies today builds on their ability to choose among multiple jurisdictions. Importantly, M&Es are capable not only of relocating across jurisdictions, for example, to incorporate or reincorporate overseas, but also to splinter their operations across multiple jurisdictions. In other words, they can mix and match jurisdictions. They can benefit from the corporate governance regime of one jurisdiction and the securities regulation of another. They can use the IP regulation of a third regime and pay taxes, if at all, at a completely different jurisdiction. And as Ron tells us, city lawyers saw these opportunities from the get-go. And I quote again from Ron's introduction, "The new imperial and global company law reality looked quite different from the perspective of incorporators, investors, and their lawyers. Unlike the government in Westminster and Whitehall, the City of London celebrated the failure of the company law unification project. For city lawyers, bankers, accountants, and investors, the mumble jumble was an opportunity for form shopping, maneuvering, evasion of regulation, and later also of taxation. Official London, on the other hand," Ron tells us, "believed in uniformity for a few reasons I won't go into for the lack of time. But as Ron describes, the empire grew too big to be able to govern from London, and the hopes for unification failed. In the tax area, moving on to the state reaction perspective, so in the tax area, as in the case of incorporation, there is certainly no unification among independent states. States saw and still see taxation as closely related to their sovereignty and insisted on their independence in designing their tax rules and rates. But independence did not stop at designing separate and different tax systems. States' independence quickly yielded competition among them. Thus, states were and still are competing for the positive spillovers M&Es may provide. States seeking to attract jobs, knowledge, capital, and innovation try to lure multinational enterprises by offering them attractive taxing and spending, quote unquote, deals. Competition forced them to reduce their tax rates, thus undermining their ability to collect taxes and pushing them to price discriminate in favor of mobile factors. The lack of coordination resulted in a spectacular mumble jumble in the tax area as well, which multinational enterprises, with the help of their tax advisor, were quick to use and even abuse to their benefit. And I know that this crowd is mostly familiar with the strategy, so I'll skip that part in the sake of time. Now, in sharp contrast to states strongly defending their independence and insisting on making their decisions unilaterally, multinational enterprises operating as groups were able to splinter their business operation as well as their legal interaction with states. And thus, when the British Empire receded its global span of control and gave way to a variety of legal regimes, M&Es were quick to utilize the gaps and frictions within the system to their benefit. While such competition has some virtues, it has two major drawbacks. First, it is far from being perfect competition. So in terms of efficiency, it's imperfect. And second, it undermines justice. It seems as if, and this is one of the questions I would like to ask Ron to address. So it seems as if when the British Empire ceased to be able to operate on a global scale, it gave up more than its own sovereign power. True, the decline in the power of the empire emancipated states and gave them the power to pursue their own goals. And yet it also facilitated, indeed it launched a rather unbridled competition and fragmentation, which de facto disabled the ability of many states to have genuine tax sovereignty, and is a main obstacle of states' contemporary efforts to regain control over their tax systems. In other words, the tax system is a good example of the ability of M&Es to escape the control of the state, indeed of any state. Importantly, by opting for foreign jurisdictions, multinational enterprises were able to draw governments into their own game. Instead of the traditional interaction between governments and businesses, where we usually think of corporations as subjects that must comply with the demands of the government and can apply for certain benefits, prerogative, and protection, or certain changes if they wish to lobby for some. In the market regime, governments are practically disarmed of their sovereign power. When governments operate as market actors, they compete for multinational enterprises' business. And thus, rather than imposing sovereign power, governments themselves are subject to the rules of supply and demand. On this marketized version of the interaction between states and businesses, multinational enterprises were very quick to grasp the opportunities that the market regime offers. And now some, particularly weaker states, seems as if they are the ones who need to escape the control of multinational enterprises, where states found themselves trying to outbid one another in an effort to win certain multinational enterprises' investment. So true, these weaker countries are no empires to be sure, but still, it's interesting to think about whether the market of states pushed away traditional sovereign power as we know it. And that's my second and related question to Ron. Could we read your chapter, Ron, not only as a story of an escape of the multinational enterprise from the control of the state, but rather as an even bigger story of the market taking over sovereign power? As I've hinted, only quite recently have states tried to regain their power by coordinating their policies. The recent cooperative efforts of states are, at least for now, not a success story, as the many attempts to coordinate states' policies indicate. The past decade saw a number of initiatives trying to tackle competition among states, starting with the attempts to curtail harmful tax competition, as it was dubbed, shifting gears to the BEPS Accord, which targeted the gaps and frictions between systems, and culminating with the recent Two Pillars Accord, the success of which is yet to be seen, and the emerging discussions in the UN. Such cooperation proved to be tricky, raising both technical and substantive issues. But markets, by definition, as Ron tells us, are not pre-legal. Rather, markets necessarily rely on legal constructs. The emergent market that curtails state sovereignty is a particular configuration of a market that indeed springs from a particular configuration of incorporation, and thus of corporations. This reframes in full force the moment in which we are situated now. Countries are struggling to cooperate in order to regain some of their sovereign power, and thus their best way forward may be to cooperatively change the rules of the market game. So before I conclude, I can't resist but convey a word of caution here. As I keep urging, cooperation itself is not enough, and interjurisdiction competition is not the enemy here. Indeed, in redesigning the rules of the market, even if you believe that competition should be tamed, to make it more efficient and incorporate justice, and even if we believe that the power balance should be recalibrated to reduce multinational enterprises' power, we must not resort to simplistic thinking that the collective power of states is necessarily good. Just like competition, cooperation is a tool, and thus both should be designed in order to lead us in the right direction. And so, just as market competition should be designed in ways that promote our goals, so should cooperation. Indeed, another lesson we can learn from Ron is that imperial power tends to grow too big to rule and thus to unravel. An international coalition of states might lead us in similar direction if we don't properly design it. So thank you, and I pass on the mic to Ruth.
Should I ask, Ron, did you want to respond to that? And then
you're muted, Ron. I think
maybe I'll accumulate both of your reflections and respond to both. I don't want to take too much time.
And
Okay,
may I please take this opportunity to ask people to raise their hands if they would like to come up on the line next.
So fascinating chapter, really interesting comments by Tsilly as well. And my questions are in a similar vein. So the chapter seems like it tells a story of the triumph of the corporations over the states that are trying to regulate them. And my question is whether this story is really over and the corporations have won, because as Tsilly said, we're starting to see, or maybe there always have been attempts by countries to wrest back local control. And so I just want to talk about maybe a few modern equivalents to the French real seat doctrine that you discuss in the chapter. And so, one is the minimum tax that Tsilly just described, right? A bunch of countries getting together to promise that they will assess a minimum tax on corporations. If that works the way countries hope it will, then that's going to frustrate a lot of the planning and disaggregation and splintering and mixing and matching in the tax area. The other examples I can come up with are all from the United States subnational, from the US states. So California and New York, which are both very large states in which multi-state corporations and internationally active corporations are active, both refuse to apply the internal affairs doctrine in cases where, in limited cases, so cases where you have non-public companies that have significant connections to the states, and the details of the laws, I don't think we need to get into, but basically, if there's enough, if you're a non-public company or privately held, you have enough connection to California or to New York, then California and New York will not apply the internal affairs doctrine. Now, of course, if you're incorporated in Delaware and you end up in Delaware Chancery Court, and you're described by one of these laws of California or New York, Delaware is still going to apply the internal affairs doctrine to you and reject California or New York law. But still, you know, it kind of tees it up. You know, this could end up being in our federal constitutional court. And so you might have, you know, a supranational or here a federal court deciding the issue. Recently, California passed a regulation saying that public companies, even if they were incorporated in other states, if their principal office was in California, then they had to have a certain number of women on their boards. And so like board composition, typically we would think of that as something covered by internal affairs. Like that's debatable perhaps, but you know, this, but you see California kind of reaching out and saying, okay, internal affairs is only going to go so far, and we're going to assert some local control over the company. This regulation ended up being held unconstitutional by California courts in violation of the state constitution for sex discrimination. But you can see just sort of the effort to take control back. And then even outside internal affairs, I mean, with no debate outside of internal affairs, you can think of recent legislation by California again that says that pork can only be sold in California if it's the hog that it came from was housed in a cage of a certain adequate size. So it's anti-animal cruelty legislation, but pork producers in other states said, well, that had laxer regulation and would have allowed the pork to be bred in smaller cages, said that California couldn't apply this legislation because it was extraterritorial and created an undue burden in violation of our interstate free trade provision in our Constitution. And here the Supreme Court allowed the California rule to stand. So our court, you know, rejects the idea of mutual recognition, which makes manufacturing laws highly portable in the European Union. So, you know, that's my first question. Can this pendulum swing back here? Is the story over? And then my second question is, you know, okay, so how do, I mean, you've convinced me of the historical story, but similar to Tsilly, I'm wondering, like, what do I do with this history? How do I evaluate it? You know, if in the United States, where we're taught that, you know, the Delaware effect and charter competition is the genius of American corporate law, okay? In Britain, you're telling me that it's the dastardly machinations of British multinationals. Well, fine, so what, right? That doesn't make the internal affairs doctrine any less efficient. It doesn't make it any worse at promoting shareholder value. So, you know, the last question is sort of like, what are the values that we should be considering here? How should we think about this history? Do we care about maximizing shareholder value, maximizing global wealth, distribution of wealth, democratic accountability, you know, ESG, local control, and so on? So how should I think about these? I assume this is in the rest of your book, but I just want to invite you to talk about that.
Okay, great questions. I'll try to be relatively short in order to allow others to ask questions. So for some of the questions, I might provide answers. For others, I think that the way forward is through a dialogue. Since I'm an historian, I from time to time touch upon and teach contemporary corporate law, but I think like an historian and my motivations are historical. So I approach this. So one thing that we have to bear in mind is that my period is an imperial period in which we have one great empire, the British Empire, controlling, as we said, a quarter of the globe. Next to it, a few other empires, many colonies, and some mid-sized countries. This is a totally different reality from today's reality, in the sense of having many more independent states playing against each other or collaborating. So the reality is different in that sense. Another sense in which the reality is different is that in my period, that is 1844, mid-19th century to World War I, globalization was a very new phenomenon. They just encountered it for the first time on such a scale. There was some global trade before, obviously, since maybe the 17th century. Trade in spices, trade in silver, precious metals, and a few other high-value goods, but nothing like the globalization of that period ever took place before. So it was a new thing for them. They were learning by doing, and they were confused. It doesn't mean that today we are not confused by some new developments, but then the entire terrain was, the entire phenomenon was a new one. And those that were faster in grasping what was going on were the ones to get richer and accumulate wealth. So one difference is the existence of an empire. The other is the novelty of the phenomenon. And then we have to remember that we can kind of compare the British Empire to today's kind of international arena, or to specific federal states like the United States. And Britain was not exactly a federation in the US state sense. There was one parliament, the Westminster Parliament, that could legislate for everyone, for example. In the United States, the Congress in Washington, D.C. cannot legislate in all fields, but only has limited sovereignty based on the US Constitution. So the British of the time could intervene more heavily. And they didn't, maybe because of lack of capacity, maybe because of the lack of will, lack of understanding. And one more point in Tsilly's remarks I would like to refer is whether this is a taking over by the market. Definitely in a sense, yes, but just at the end of my period, we enter World War I, in which states accumulate much more power, economic power, they regulate more, they draft more, they control more. So it's not that we have a linear development from state control of the economy towards market control. We have ups and downs during World War I, during World War II, and these ups and downs might continue into the future. I'm not sure. Another point I would like to mention is the point which Tsilly may have just touched upon it, but I would like to piggyback in order to kind of raise an issue I did not fully develop. What you can see here is a great extent of inconsistency, incoherency, and lawyers and governments were willing to live with these inconsistencies, which are against the basic intuitions of lawyers. That is, you can have apply different legal personality theories to different fields of law. You can have a kind of grant theory in one place and contract theory in another field of law, and real entity theory in the third realm of law. When it comes to dealing with enemy, you have one solution. When it comes to taxation, you have a different solution. And the same inconsistency applies to choice of law rules in private international law. You could have a place of incorporation in company law or in some aspects of company law, and really see it in taxation, and somehow these live together, and no one was trying to call for a change based on the incoherency and inconsistency. And another point I would like to kind of phrase is the distinction between multiplicity of jurisdictions and jurisdictional competition. What we see here is mainly multiplicity of jurisdictions. There are many choices around of where to incorporate, but there is no clear evidence that the legislators themselves were trying to change the law in order to attract more incorporators. And this is somewhat different from what at least some scholars view as going on in the US today, or over the last century. So there was a competition in the US in which New Jersey intentionally led the way, and then Delaware intentionally led the way. Maybe not all jurisdictions wanted to take part in the competition, but some jurisdictions did want to take part in the competition. And more recently, Nevada joined in, and this touches upon the points raised by Ruth. So Nevada is now competing for some segments of the market, but not other segments of the market. And there was a competition within the EU over incorporation. In my period, it's mostly the multiplicity rather than the competition that drives things. And when it's the multiplicity, the major agents, the major players are coming from below. That is, these are the investors, the entrepreneurs, the incorporators, the lawyers, the accountants, rather than the policymakers that are the major players in the story. And maybe one or two more points. I totally agree with Ruth that we should not kind of take whatever was created late in the 19th century as the very last word in terms of choice of law rules with respect to corporations, with respect to internal affairs, or to other issues as well. I mean, one of the things that I can contribute as an historian is that relatively contingency in which these rules were created. They were created in a specific environment, under specific circumstances, and one should not deduct anything from this as to efficiency of to distributional justice or global justice or whatever. We are stuck with some rules that were created in a totally different reality. One does not have to kind of abide with the general conception that common law jurisdictions prefer place of incorporation. One can definitely try to, as California is doing actively now, partly in response, I think, to Nevada, partly in response to what's going on the federal level, maybe. So I think that these issues should be placed on the table of the policymakers. And real seat creates more hurdles, more burdens to those who want to decouple, those who want to plan, those who want to avoid a regulation, those who want to avoid taxation. And I mean, planners, legislators do not have to follow this. And I think that another kind of lesson I drive from my period is that certainty assists the more sophisticated players. They know how to plan. And governments do not necessarily have to provide certainty and predictability. They might change the rules from time to time. And the fact that they do change the rules from time to time doesn't mean that this is necessarily an end game after which they will lose investors and companies or whatever. They can be as dynamic as the corporate economy. And what to do with history in terms of policy, I prefer that you'll answer the question rather than me. I'm trained as an historian. I'm affiliated with the law school. I was a dean of a law school, but I'm educated primarily as an historian, and I know that the more I think about the historical questions through normative lenses, the more I distort my wish to understand what's going on in history. And I kind of politicize in, and not necessarily a positive, but rather a negative way, my historical work.
That's what the historians always say. It's the consistent answer from all historians across time.
I mean, all historians are political in a sense, but they don't want to put their history, their politics more explicit, and some of them at least don't want to shape the entire projects by the political inclinations, yes. So I
Thank you.
think that I'll stop here and leave some time for questions.
Thank you, Ron. That was fascinating. So I think we're almost approaching the end of our session, but I think we have time for a couple of questions if people would like to jump in. I don't see any hands raised, so please raise your hand if you'd like to join in. Okay, I guess we have run run our audience past the promised time. So let me conclude this session here. Thank you, Ron, for this fascinating chapter and discussion. And we very much look forward to the book in its entirety. I think those of us who have had a chance to read this chapter and more have enjoyed it tremendously and are eagerly going to look forward to it. And for everyone on the call, I know it takes some time to digest, and knowing Ron, I'm sure he'll be open for comments offline as well. So feel free to email either Ron or Ruth and I, and we'll pass your comments to Ron. Ruth, would you like to join in concluding?
Just thank you very much, everyone, for being here. Stay tuned for the next Oxford, Virginia Legal Dialogue, and many thanks to Ron Harris.
Thank you very much.
Thank you,
Thanks for
Ron.
the opportunity.